Hey everybody, welcome to Signal and Noise. Episode 7, we're approaching double digits. Andrew, how are you, sir?
I'm doing great. Glad we are keeping the momentum rolling.
Yeah, I'm Brian Lamar. Andrew DeSolis, as always, joining me. Today we have a special guest, Howard Fienberg, the VP of Advocacy, Senior VP. Don't want to take away the Senior VP of Advocacy for Insights Association. How are you, sir?
I'm old. That's why they added the senior. Great to be here. Good to see you guys or talk to you guys, and looking forward to some good discussion.
Yeah, today is, it might be, this is, I don't know, third or fourth time we've had Howard on over the course of the last few years. And it's probably one of my favorite guests because I nerd out on this stuff. So we'll talk things around policy, what's happening in legislation, and nerdy stuff like that. And some of the things really affect us on a day-to-day basis. They're important to know and understand, but they're hard to, when you're doing your normal day-to-day work, you don't think about things like that, like what state laws might change or federal law might change and things like that. And so this is always my plug. I say this every time I probably speak to Howard. He alone is worth the price of membership for Insights Association. If you're not a member, join. He will, I don't know how he does it. I don't think he has a team of dozens of people, but it feels like it when you summarize what's going on by state and going on in the Fed. And not only that, you look globally as well, how that affects the U.S. And so we appreciate it. And maybe that'll lead me into my first question: is inside association policy issues? Is there anything going on that us researchers should be aware of?
So the number one issue for us is always, since I started, I think it has always been consumer data privacy. And yeah, we've reached a point now when there are 20 different states with comprehensive privacy laws of their own. And most of them pretty similar to each other. There are minor differences state by state. Some of the more outrageous differences come up when you deal with California because they were first, and they're always trying to make sure that they're ahead of the curve and doing dangerous, damaging things to business wherever they can at every turn. So every year they tinker and mess around with it. Plus, their regulatory agency, the California Privacy Protection Agency, the CPPA, they're always trying to come up with the next set of regulations to go beyond their statutory authority and do more things, of which they actually just recently put out new regulations to put meat on the bones, as they feel it, of additions to the California, right, the CPRA in the CPVA, of how you do a privacy audit and how you do risk assessments. So the privacy security auditing, bigger deal for bigger companies, and it's going to come into effect more quickly the larger your company, because that apparently produces a more significant risk. But they're all getting into much more of the weeds than a lot of other states when it comes to what they're going to be expecting. And I believe it's on the audit side where companies are going to have to start doing that very soon, and they're going to have a senior leader at the company sign off on it in an attestation to the state regulator, which puts not just the company on the line for legal liability, but an individual of the leadership directly on the line for liability, which is a fascinating change that we've not seen before. Not a good one either. And they also added in a whole set of new requirements for automated decision-making technologies, which could impact just about anything on the automation side as it relates to research subjects who get incentives for participation. So most everybody on the online panel side and their research subjects, and defining automation gets very cagey. There's an extended definition, and there's a definition within the definition to try to further tease it out. A lot of it is more around notice and some choice than anything else, but it is going to require some internal policy and procedural changes at potentially a lot of companies, depending on how those automation definitions will apply to your company.
I have so many questions right off the bat.
Yeah.
You want to?
Yeah, me too. Me too. So I think it's probably safe to say that if you're compliant with California, you're generally safe. Is that fair, or what other major?
The answer is you're right on average. Kind of like when people were saying, well, we're GDPR compliant, so we're fine. Like, yeah, everything's kind of around the same basic principles, but the details get much more murky and the definitions are not don't line up in a lot of the states. But also, there were different states with different requirements that come into play. Like Minnesota, I think it was, in Maryland, they've got these requirements for data minimization that don't seem to exist in other states. Some of the states that have restrictions on online tracking that kind of are reflected in California, but they're different. And the problem is, and each of these states have their own way of doing things, and some of them have their own regulatory agencies, so they get into much more minutia after passing a law of how it's going to impact a company. So I would take this opportunity to note that's why we've been working really hard for the last few years trying to get a federal privacy law to preempt all these different state laws, give consumers some important across the board protections and transparency, but try to clean up this mess of 20 different states. And I didn't even mention the worst offender in that is not even California. It's Washington State, which has a healthcare privacy law that is only ostensibly about healthcare, because their definition of healthcare information is basically just personal information like it is everywhere else. And they have a private right of action. So when you screw up with a Washington State resident and run afoul of that law, you're potentially looking at class action lawsuits from individuals. So it's a rough environment out there, which is, again, why we've been trying to get Congress's help on this. And I can go into details and a little bit on that if you like as well.
Well, let me ask what perhaps is a naive question. But you raise an interesting point with that example from Washington. When we are in the course of fielding online research, most of our listeners are doing online surveys. Obviously, you're with the Insights Association. The place where the respondents live, that is the laws to which you are beholden when involving them in the research process, or is it where our organization is headquartered? It's a very high level question, but I'd be curious.
I mean, the answer is generally that it is where the research subjects are based. Where they're resident is the privacy law that applies. And there are some variations of that, so I can't make like an across the board legal pronouncement on the matter. But that's usually the most important thing, which is why even determining if the law applies to your company or to your, or maybe your client or your partner, you're trying to look at how many research subjects you have information on in a certain context, or whose information you share on, during the course of a given year. You're narrowing out, all right, how many tens of thousands of research subjects from Washington or from Idaho or whatever. I mean, Idaho doesn't have a privacy law, comprehensive privacy law of their own yet. It's just as an example, that's tends to be what you are looking at. And so it matters where the research subject is much more than where you are based.
Andrew, this might be a question for you. I wonder if this is an end around way to improve data quality, because at Railway Rocket, we know our panelists. We have PII on all of them. We know we have down to the zip code. And so we know what state they're in. We know in theory what privacy laws affect them in each state or even globally. Many do not. A lot of surveys are taking with intercept online traffic, dynamic sampling. Who knows where the sample comes from? And I wonder if that puts them at risk. That might be a discussion point for another day, Andrew, but that's something that's rather interesting, because I know at California, for example, this might be for only companies that are headquartered in California, but you have the right as a resident to get all the information that a company has about you. And so I've done that myself. I've contacted Apple and Amazon and said, "What do you know about me?" And they have to send that. And I think you have the right of erasure. And I think that if sampling companies aren't aware of these laws, that's certainly a risk that they're probably not even thinking about right now, because I don't think there's been a major lawsuit. But I think there's potentially, anyway. That might have been a rant, or that might have just been a 2-minute kind of soliloquy there. I don't know.
Well, and let me have kind of a follow-up, and then Howard can comment on my follow-up and tell me all the ways that I'm wrong and what I'm missing, which will be helpful. But is it more of a risk or less of a risk? Because if they don't have your name or
Mhm.
or where you live, and you're just an ID number that you were intercepted from Clash of Clans, and you took a survey and then you got a chest of gems or whatever, um, and they don't have any PII, then is the company at less risk? And I think as well, the few legal matters I've been involved in my life is not kind of what you imagine, right? I feel like the attorneys, it was like, whose line is it anyway? Everything's made up and the points don't matter, and we're just going to like argue about. There's a lot of gray area. In fact, it's all gray area, and so I wonder, Howard, if you can give some color to us and to our listeners of, okay, 20 different privacy laws. We're all doing research all across the country on dozens of studies every single day. How does it practically hash out?
How does it practically work out? Well, now is a very good opportunity for me to point out that I'm not a lawyer, and none of this constitutes legal advice. Just to protect everybody involved. So, I mean, practically, look, you can go in and, look, I'm sure lots of companies are trying to find ways on the back end to make sure that they are following every single state's law as it may relate to them. How does that work in practice? I'm not sure because I'm not there on the back end with all these companies that are doing their best to do it. But there are practical ways to try to meet the basics across all the states. And it might be a little bit of mixing and matching, but it's doable. Your question about if it's better to not have a whole lot of information, that's an answer of it kind of depends, because a lot of the state regulators, and I mean certainly the privacy activists, they feel that anything is potentially identifiable, and if there is a possibility in some cases that you could rework the information and eventually figure out who the individual is, then the information is personally identifiable and you have no excuse. So there's a whole cadre of people that feel the entire concept of anonymization is non-existent. And those are the kinds of people we have to fight with on a regular basis, because we're always trying to get protections for pseudonymized data. That you only have, for the most part, and even in transactions between companies or between partners and vendors and clients, when you're only dealing with, research subject 5,622, and you've hashed out all sorts of information that without the key, they can't unlock. In our opinion, and in the opinion of lots of companies and lots of industries, that's something that should get you out of all sorts of privacy restrictions in the different laws. But California, for example, doesn't really feel that way about pseudonymized data. They mention it, and they kind of define it, and say, "Yeah, we'll let you out of a couple things, but not much." And it's actually been one of the key things we've been hammering at the federal level as we try to come up with legislation with Congress, is the importance of protections, and not protections. What am I thinking of? Privileges. Sorry. That if you are pseudonymizing your data and following good practices, and we can, like if that's from NIST or some other standards agency on practices when it comes to privacy and security, if you're following those practices in pseudonymizing the data, you shouldn't be penalized and put under the same kind of restrictions as a company that is dealing with the data unhashed and is not protecting it when they're both using it and especially when they're selling and sharing it. It's very different environments, and some people are really accepting of that, and then you have some more extremes that again think that anything is because anything might be re-identifiable, therefore everything is identifiable.
I have another question, but I might take us in a different direction, Andrew, unless you want to have a follow-up.
Please.
Okay. You mentioned the CRPA, CCPA. You live in DC, you advocate for federal legislation. what do you do when, let's say, California said, you know what, we want a minimum incentive per respondent, regardless if they qualify for a survey, it's $10, and this is now the law. If you qualify for a survey or not, you must pay them $10. How do you advocate at the state level? Do we have local people in Sacramento, California? Do you partner with other industries? How what do you do then?
So it depends on the situation in the state. In California, we tend to work through the California Chamber of Commerce because we are members of the chamber along with lots of industries. And to be fair, we're not involved in all the things that the chamber does. We're involved with the chamber specifically on privacy, data security, AI type issues. We're part of a group that works on those issues. The issue that you cite, yeah, which we dealt with in, I guess, starting in 2020 and through maybe and even into 2022. Years start to blend together. You'll forgive me. Where they tried to put a minimum wage requirement on research subjects. That was something where we had to go get a specialized lobbyist to help us in the state capitol, and we worked with them on trying to maneuver through the system to get a fix because it was something so specific. On most of the time when we're talking about the privacy AI type issues, we're on more or less the same page as a good portion of other industries that are coming into play. For something like that, it was very pecuniary, it was specific to us, and there was no way to go big on that. That required a bit more specialized expertise. And and it'll depend. I mean, sometimes we're just submitting testimony to hearings, and oftentimes that can make enough of a difference that we don't have to go full throttle and be more involved in that. Because simply submitting it and sharing information might be all it takes. It really depends.
Awesome. Are there other IA policy issues that we should be aware of beyond data privacy? Which, thankfully, I feel like that's taken a backseat a little bit, or maybe I'm ignorant to it, but I feel like that's all I worried about a few years ago. Now I feel like we're a little bit on cruise control. Is there anything else we need to worry about?
Well, the reason you're on cruise control is because we've been working with lots of other groups in lots of different states to at least hold the line. So it was a nice thing that, yeah, it seems like we're going to get through 2025 without any new additions to the roster of comprehensive privacy law states. So we're holding at 20 this year, which sounds kind of ridiculous to be cheering that. But, unfortunately, that's a positive thing when you go through at this point, when you go through a year without adding another one. Some of them they continued to tinker and build out those laws, but holding the line a little bit was positive. And yeah, we've been busy with Congress. I mean, the House in particular, they have a privacy working group that's trying to go back to basics on developing some privacy legislation from scratch. So we've had some good interactions with them. They were quite receptive to almost everything we were asking for. So I'm positive and optimistic on that. And other issues, the census remains one of our ongoing top issues. And yeah, again, as I get to explain to legislators all the time, like, yeah, we're in year 5 of a 10-year cycle for a decennial. And here's now already the time when you need to be jacking up the funding. You need to be focused on certain things. The 2026 census test is supposed to go off next year across 6 different sites, 6 states of all different sorts, and rural and some native and reservations, urban, suburban, all designed to shake out how they're going to do the full head count of the country at the end of the 10 years in 2030. I'm assuming even with all the hiccups that I expect to happen along the way that test will still happen. But there are concerns along the way, including the fact that while the House is going to pass a continuing resolution to keep the federal government open tomorrow, sorry, they're going to pass it today. What happens with the Senate is kind of up in the air. So even that, I mean, a lot of the data that companies rely on from the Census Bureau, including, very soon the ACS, the American Community Survey data, a lot of that stuff is going to be delayed. And, there's likely going to be some gaps in different data sets because there's not going to be data collection done during a shutdown. But even during a continuing resolution, the Bureau continues on only doing what it was doing before with a certain amount of money. That means any new innovation is not going to happen. Any new things that they were going to be doing to try to build out, especially for the 2030 census, that's not happening during a continuing resolution. So it starts to get really hairy really fast because it is a 10-year operation to build up to the count.
It's hard to believe 10 years. I don't know. I guess I'm getting older too. I need a senior beside my name. I feel like we just did the census and here we are. We're closer to the next census than the previous census, and that's crazy to me. And the importance of that for our industry is, I don't know, that seems like the sky is kind of falling. I'm sure it'll work out, but it feels very sky is falling.
Yeah,
I mean, not,
when you're focused on the detailed operations along the way, yes, it certainly can feel like the sky is falling. I don't think the sky is actually falling, but it certainly was an interesting end of summer when the president chimed in at the beginning of August calling for a new census in his typical kind of oblique, hard to pin down terminology where you could read it 5 different ways. We chose to accept that he would accept and be excited that he would care to talk about the census at all in the middle of the decade, which normally doesn't happen. The president usually doesn't talk about the census until it's almost happening and it's too late to do anything. The concept that he would be supportive of more funding and more new and not just new investment, but new ideas on how to do it. We think it's great. I don't know if the moment's passed, who knows? But the interpretations that other people had that he was going to suggest that there needs to be a mid-decade census, which is something that the law allows in year 5. You can do a mid-decade census, but you would of course have to prep for that. And
yeah.
the 2025, the fiscal year for 2025, is ending in what, 2 weeks? Less. So,
Yeah.
uh, and
Oh,
time's kind of up on being able to pull off a legal mid-decade census. Not to mention, it couldn't be used for what he was implying he
right.
would have wanted it to be used for, which is apportioning of congressional districts and redistricting. That's the one thing you can't use a mid-decade census for.
Okay. Well, thankfully, in Ohio, we still haven't finished redistricting from the 2020 census. We still have lawsuits, and we're going to redo it again this year, I think. And that's just
Yes.
that's here in Ohio. I live in, I think, 3 different districts in the past 10 years, so it's a little crazy. Okay, I have a topic. Anything happening with artificial intelligence from a inside association standpoint, from a federal legislation standpoint, anything that might be coming down that we should be thinking about getting ahead of?
Well, aside from people often mixing up the IA and Insights Association with
AI.
AI, so there's, and I can't speak directly to the code, which was revamped recently and with some updates that the members just approved,
Yeah.
to try to make sure that it's more clearly including AI as part of the ethical code. It didn't actually require that much in the way of change because the code applied regardless. It was a matter more of reminding people that the code still applies, even if you're playing around with AI, which people should be with care and conscience. But from a legislative regulatory standpoint, we've been involved in, and sometimes directly, sometimes more watching on what's going on at the state level in particular. There are now laws on that sort of kind of touch us on the edges in
Mm.
Texas, Utah, and Colorado. Sorry. The Colorado one has, yeah, and Texas is coming into effect soon. Colorado just extended when theirs is coming into effect. They're trying to buy themselves more time in the legislature to tinker with it because the governor hates the law. He was actually one of the only governors that piped up in support of an effort in Congress to have a moratorium on state regulation of AI because he didn't care for his own state's proposed law. So they're going to continue to work on that in starting in January, and not sure how that exactly will shake out. I mean, on average, the Colorado one, as written, was not a big deal for our industry because it was focused on uses that don't seem to really apply within our space. The only thing that really seemed to apply in it, which is something that we're pretty comfortable with, were requirements of transparency with people when they are interacting with or when AI has been involved in something. which is directly in line with the IA Code of Ethics. How convenient. And the law in Texas originally was going to be doing basically the same thing. We actually came out and endorsed it, said, hey, that's a good idea. It got shrunk down such that it really mostly just impacts the state government instead of the private sector. And there's a little bit of there in their law on misrepresentation and fraud and malfeasance, which I don't think would actually apply to anybody that is following generally law abiding in the insights industry. And Utah again has an existing requirement for transparency to consumers when they're interacting with AI. They shrunk that because it originally also included B2B in any interactions. Now it's even only for consumer interactions. But even so, that's a sensible thing for insights companies to be doing when they're using, say, an AI chatbot. It's just basic fairness and transparency to consumers that is not a bad thing, and hopefully would keep those research subjects involved, and if they have at least a basic chance to be informed. And there is a lot of discussion about federal regulation of AI, and there's not a whole lot of movement on it yet. We're talking with folks in the House and Senate, more Senate than the House at the moment on different things. But again, most of it seems to be going the way we want, which is focused on transparency. And I think that's one of the most important things that we can fight for at the moment.
Absolutely. Yeah.
So Howard, one kind of a final topic for you, I guess. There's a lot of things here that I feel like we could just talk to you for hours and hours and hours. And at least for me personally, it's something that we get so focused on what's happening just within our little space that we're less aware of what's going on outside of it, even though it definitely affects us. Is there anything coming down the pipe, anything you've heard of that kind of worries you? Like, what should we be on the lookout for in the coming 1 to 3 years that would pose a threat, or maybe not a threat, but would create significant change for our industry?
There continues to be interest at the state level in changing how independent contractors are treated and defined. This issue we mentioned at the beginning of the podcast when Brian, you were asking about the move in California earlier this decade to try to require a minimum wage for independent contractors in our space, which means research subjects. And there are some similar rumblings of that. Like at the moment, I'm dealing with New Jersey. It's a quiet thing. It's not really clear where they're going to go with it. They're not mentioning research subjects, so it's not like we're drawn into it so explicitly the way we were in California. But and they have a long time standing statute that uses what is called an ABC test of classification for whether someone is an independent contractor or an employee. And research subjects fail the ABC test. It's been an ongoing problem for years. The only positive is that our companies are rarely challenged on it, because most people look at it in a common sense way and say, look, none of these laws were meant to apply to someone who participates in a research study anyways. So even if someone, it's usually cases involving someone applying for unemployment insurance and claiming that they participated in like an online focus group or something and said, well, here, look at me, I've been earning money this month. I've been trying to, make a living best I can, hand to mouth. And look, I participated in this online focus group and, I made $25 or something. And then the state agency starts to churn and say, hey, we haven't been receiving any UI payments from this company for all these research subjects. We should do something about that. And thankfully, we haven't had such cases for a while. But that's usually where it spins from. And the idea of New Jersey putting out much more expansive regulations right now on their ABC test, which I went through, and like there are little pieces of it where I thought, well, that kind of makes it easier for us. Again, because we're such a pecuniary kind of interaction, But there are pieces of it that we simply, a research subject can't meet the test. And I worry that if they move forward without changes, that it could pose problems for us in the next couple years. So I'm keeping an eye on that to see how much engagement we need to do with that labor agency in New Jersey. That's just one example among many that we're always trying to keep an eye on.
Well, I think we've spent enough of your time today, Howard. Have you had any fun this summer? Anything you want to talk about that's like personal in nature? Either Andrew or Howard, I can bring up something. Did you take a vacation?
Me, I got to go with my wife up to Buffalo to see her family, and up to Toronto and the nether reaches of Lake Muskoka to see a bunch of my family and friends. And there aren't tons of horribly wealthy people in Canada, but it sure seems that a lot of them have houses on Lake Muskoka based on my quick little spin around the lake. But yeah, no, very nice vacation. But I didn't get to see fireworks either for Canada Day or the 4th of July because Canadians, for some reason, don't imbue the same importance to their Independence Day equivalent as we do for our Independence Day.
Interesting.
Very sad.
I'll share a little personal news for anybody that's still listening.
Please.
You're still listening at this point, man. We love you all. First, Howard, before I get into it, Plug Insights Association.
Insightsassociation.org. Highly recommend keeping abreast of things. The majority of the information on the advocacy side is behind the members only wall. So it's why you might not know a ton of what's going on a regular basis if you're not a member. Although we are trying to get up once a week, at least a rundown on LinkedIn called IA on the Hill, and trying to get out on more podcasts like your guys to make sure that at least more people are being kept aware of what's going on U.S. legislation, regulation, and law.
So important. One of the most important parts of our industry you got to keep on top of. Thank you for joining as always. My personal news, you don't know this, Howard, is that I have an adopted son that I am the biological father of that I reconnected with a few years ago. And so it's kind of an amazing story. I can tell it again if anybody ever asks. But in 2019 we reconnected. He was 28 years old, and he just had a child yesterday. So I guess I'm technically a grandfather. Isn't that weird?
Congratulations.
Yeah, mazel tov. Very nice.
Yeah. So yeah, thank you. And I'm going to go see him hopefully in the next couple days and this weekend maybe, and go see him. And yeah, so it's kind of exciting. My parents are extremely excited. It's kind of a cool story, just reconnecting with him, and now he's part of our lives. And so congratulations to grandbaby Lamar.
That's awesome. Congratulations, man.
Thank you.
That's awesome.
As always, thank you for listening to Signal Noise. We appreciate it, and we'll be back to you with more news, more guests. If you have any feedback, let us know. Thanks, everybody.
Thank you.
Awesome.